The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to the GC3 Startup Network webinar on protecting your patents from post-grant challenges. We will begin shortly. I'll put myself on mute just for a minute or two to allow others to log on. All right, we'll get started. Welcome again to the GC3 Startup Network webinar, Protecting Your Patents from Post-Grant Challenges. This is the second in a three-part series devoted to patent law. My name is Julie Manley, and I'm the coordinator of the GC3 Startup Network. The Green Chemistry and Commerce Council is a cross-sector, business-to-business network of companies and organizations working collaboratively to accelerate green chemistry across sectors and supply chains. The GC3 members are champions and innovators, as you can see from our more than 120 members across the value chain. This webinar was organized as part of the initiative within the GC3 called the GC3 Green and Bio-Based Chemistry Startup Network. The goal of our network is two-part: to support green and bio-based chemistry startups, and also to introduce the large strategics within the GC3 to new chemical technologies, as well as partnership and investment opportunities. The members of the GC3 Startup Network are roughly 26 companies now, and we are continuing to sign on more. These startups are able to tap into our network of large strategics through our mentoring program, as well as, or I should say, as what we call the Strategic Connections program. And they may also participate in our technology showcases, where we bring together startups to present to and network with our large corporate members. And these startups can participate in workshops on key issues, such as leveraging partnerships to accelerate innovation. Our next technology showcase will be at the GC3 Roundtable on May 8th, which will be hosted by the Eastman Chemical Company in Kingsport, Tennessee. New this year, the technology showcase is integrated into the GC3 Innovators Roundtable, rather than as it used to be the day prior, as it was done in previous years. We have 10 startups with technologies that are designed to match the interests of our large GC3 members, who have been selected to present their technologies to the full GC3 audience. Registration for the GC3 Innovators Roundtable, May 8th through 10th, is now open on our website. And I should mention also that early registration rate ends this Friday, March 2nd, and actually would save you anywhere from $50 to $100, depending on your registration category. So as we go forward into today's seminar, I'd just like to quickly go over some logistics. Due to the number of participants on the webinar, all lines are muted. If you have a question or comment, please type it into the questions box located in the control panel. And we do encourage you to type in a question at any time during the webinar. You do not feel obligated to wait until the end. Just type away anytime a question comes to you. And apparently I lost that. All right. I think we're almost done here. So I'd like to transition and introduce our presenters today. We are very pleased to present this series. Again, this three-part series offered by the Finnegan, Henderson, Farabow, Garrett, and Dunner law firm. This webinar will specifically focus on key considerations and strategies for developing and maintaining a global patent portfolio. I am pleased to introduce Maureen Queller as the moderator of today's webinar. Maureen is stepping in for Shayna, who was scheduled to be here but had a conflict. Maureen is associate with the law firm. She holds a BS in chemical engineering from Penn State University and a JD from George Washington University Law School. Maureen represents clients in inter-parties review and other contested proceedings before the Patent Trial and Appeal Board of the U.S. Patent and Trademark Office. Maureen also has an active patent prosecution and counseling practice preparing and prosecuting U.S. patent applications on behalf of domestic and foreign clients with an emphasis on chemical subject matter, including polymers, cosmetics, pharmaceuticals, oils, renewable diesels, and catalyst technologies. So thank you, Maureen, Mike, and Mark for offering to present today. I will now transition it over to you, Maureen.
Thank you so much, Julie. As Julie mentioned, I am your moderator, Maureen Queller, and before I introduce our panelists, I would like to repeat what Julie said and really encourage all of the attendees to use the question functionality and submit any questions, big or small, for our panelists to answer throughout the proceeding. And I'll be happy to interject if it's a question that's relevant to what they're talking about, and go ahead and pose the question to our panelists. So on to our distinguished panelists. I'm very pleased to announce that today Mark Feldstein and Mike Flibbert have put together a very engaging and informative presentation on protecting your patents from post-grant challenges. Mark, or Dr. Feldstein, is a partner in Finnegan's Chemical and Metallurgical Practice Group. And there we go. Mark's science background is in chemistry with a doctorate in physical chemistry from the University of Pennsylvania. Mark's legal practice focuses on protecting and enforcing patent rights, whether that be during post-grant trials at the USPTO or in district court litigation. And his practice area covers a wide range of technologies, to name just a few: pharmaceuticals, biochemistry, polymers, and small molecule chemistry. Mike is also a partner, and he is the former practice group leader of Finnegan's Chemical and Metallurgical Practice Group. His educational background is also in chemistry, and his legal work has also focused on such a wide variety of tech areas, also including pharmaceuticals, biofuels, chemical engineering, agricultural, and material science. He was a clerk for Judge Lurie at the U.S. Court of Appeals, and his practice involves post-grant proceedings at the USPTO, district court litigations, as well as federal circuit appeals. I will now turn it over to Mark and Mike.
Thank you, Maureen. This is Mark. Thank you all for attending. I want to talk about, just give an overview, a high-level overview of what we're talking about. What are post-grant proceedings? They are basically what they sound like. They're a proceeding that happens. It happens to be at the patent office after your patent is granted. And there are a couple of types, and we'll get into the details and the pros and cons and the considerations for each. But just sort of a big picture, why are there post-grant proceedings and where do they come from? There was a perception going on for a number of years in industry, in the legal area, that there were a lot of weak patents out there that were interfering with growth and innovation rather than promoting innovation, which is the whole purpose of the patent system. And there was a perception partly driven by what some people call trolls, patent trolls, who would get what people perceived as weak patents and assert them against other companies, to try to get some value out of that. People who owned patents but didn't even practice them, and they would sue, from large companies to small companies and end up blocking innovation. And the problem is, the reason why that worked is that when you're sued in a district court litigation, which is where patents are enforced in the US, the district court proceedings are fairly involved and fairly expensive, and very often the person asserting a patent might say, okay, we're going to sue you. You could defend for millions of dollars, or you could pay us 10% of that, and we'll go away. And just in terms of risk calculation, it was often the better business decision to just simply pay some royalty to the patent owner rather than fight a multi-year, multi-million-dollar patent litigation. But people viewed that as an abuse of the system. They viewed that as an abuse of the patent system. And so there was a desire to have some alternate way to cull out weak patents that were being asserted. And so what was developed in 2012 was this system of post-grant proceedings that are back at the patent office rather than in a district court. And basically, depending on which flavor of post-grant proceedings involved, it allows a party,
Mark, I apologize,
almost anyone,
your audio cut out,
to challenge the validity of a patent that's been issued by the patent office in a relatively fast
Maureen or Mike,
and a relatively low-cost
being that you're in the same
proceeding.
room.
And that's the origins of the post-grant proceedings. And Mike, do you want to talk a little bit about the individual ones?
All right, I apologize,
okay.
Everyone. We will get this resolved.
Okay. And so I'll continue and talk about the three different types of proceedings there are. So inter-party review is the most commonly used proceeding, and it is most commonly used in part because it applies to all US patents whenever they were filed. It could be a patent that was filed 10 years ago, or depending on a few timing issues, it could be a patent that is filed issues off of a filing tomorrow. And so inter-party review is the most broadly used and most common post-grant proceeding. What it allows you to do is it allows the challenger to go to the patent office and say, patent office, here are some patents or some other printed publications, and the patent the patent is invalid. It's either not novel, it's not new, or it's obvious over these patents or printed publications. And every year there are truly thousands of these proceedings, or around 1,000 or more proceedings before the patent office, where they evaluate, they look at basically a written record of what's in the literature, the patents or the printed publications, and will reevaluate if things go in your favor. They'll reevaluate the patentability over those grounds. Depending on when the patent was originally filed, whether it was early, relatively early in time, you can file an inter-party review at any time against a patent. For relatively newer patents, there's a 9-month window after it issues where you have to wait until you can't file an inter-party review in the first 9 months after a newer patent issues. You can file this next option, a post-grant review, but you can't file an IPR just in the first 9 months. So just to sort of close the loop on inter-party review, it's available against every patent. There's just a little bit of a timing issue of when you can raise it for certain patents. Post-grant review, in a way, is a more powerful, or at least gives more options for how you can move to invalidate a patent. It's only available to relatively new patents that were filed when the law that we call the AIA, American Invents Act, went into effect. And so for newer patents, you can challenge them not just on novelty and obviousness from printed patents and printed publications. You can challenge them on virtually every ground that's available in a district court, virtually every ground to say that patent's invalid. The sections that are listed are patent law sections, and what they mean basically is 101 is something that you may have heard of, is in the press a lot. It's a question about whether it's patentable subject matter. So is the patent on something that's even at the highest level patentable at all? The next 102 is the novelty provision that we talked about already. 103, this is obviousness. But then this 112 ground is a big addition over the IPR. The 112 ground, those are grounds of patentability where you're required to have what's called a written description of your invention. The specification has to disclose that the inventors were in possession of the disclosure, the claimed subject matter. There's another part of 112 that requires the patent to have what's called an enabling disclosure. Again, to basically teach a person of ordinary skill how to make and use the claimed invention. And then there's a third part of 112 which requires that the claims be definite. Basically, the terms have to be clear and not ambiguous. And so these 112 grounds add a large area, a large new set of grounds to attack an issued patent. Double patenting is sort of a specialty ground that's another flavor of obviousness that I don't think we need to, for now, go into the details of. But because post-grant review is such a powerful weapon against attacking patents, the law set it up so that a patent owner couldn't be subject to a post-grant review forever. It was set up so that a patent that is potentially eligible for a post-grant review attack can only be attacked during the first 9 months after it issues. And so if a patent issues January 1st, 2018, you have to file your post-grant review within 9 months. If you wait until 10 months, you cannot file a post-grant review. The patent, at least as far as the patent office is concerned, is sort of forever safe on things like 112 and double patenting and 101. And the challenger is only left with the inter-party review that is above. There's a third type of post-grant proceeding, covered business method, and it's really a rather specialty ground. It's not available for, the available patents are not based on whether they're old or whether they're new, but based on what they are directed to. And so there's patents directed to financial products or services, basically like a patent on how to move money around between banks to maximize interest charges or to lower risk that any one party is going to suffer a loss. And that they got their own special provision because they were seen as being particularly abusive and potentially particularly weak patents. It's going to be phased out, so there's not a lot to talk about on covered business method for the future. They started early, they had some success, but they're going to be phased out in a little over a year. So sorry, here, what if I mute? Okay.
slide's not advancing now. Okay. Okay, everyone, this is Mike Flibbert. I'm going to talk a little bit about IPRs and some of the advantages of IPRs. IPRs have become extremely popular since the AIA went into effect. And to give you an idea, for example, there have been over 7,000 IPR petitions filed since the law went into effect just a few years ago. And so it really has transformed patent practice for small companies, big companies. So really all US companies really have to be aware of the impact of IPRs. And so if you're a startup, if you have patents, you really need to be concerned that those patents could potentially be challenged through an IPR. And you also, you may face patents as you're commercializing your technology. You may become aware of patents that you think are potentially blocking your entry into commercialization. And the IPR procedure could provide you with a potential way to kind of remove roadblocks that are standing in your way. So why have IPRs become so popular? Well, there are a number of reasons, but probably the most important one is that they have been very successful. So patent challengers have been very successful in challenging US patents through IPR procedures. And to give you an idea of that, of these 7,000 petitions that have been filed, more than 65% of them were instituted, meaning that the Patent Office agreed there was enough of an issue to go forward with a challenge. And then of the cases that were instituted, about the same percentage, about 65% of the cases that are instituted, all of the patent claims are canceled. And so it has been a really successful way for challengers to try to take out patents. Now, again, as Mark said, the IPR is a specific procedure that's limited to printed publications and patents that are prior art. So in other words, you're challenging the patent on the ground that the invention would have been obvious, or that it lacked novelty, that it wasn't new in view of these earlier patents and publications. So a number of aspects are very appealing from a challenger standpoint. The burden of proof is lower than in a district court case. It's only a preponderance of the evidence, and there's no presumption that the patent is valid, unlike in a trial proceeding. It's also very fast. These cases are decided in about a year from the time they are instituted. And so compared to a district court litigation, which, as Mark was saying, can go on for years, it's a very fast procedure. It's also, these cases can be appealed to the Federal Circuit, which is the court that handles patent appeals. And there are some jurisdictional limits for parties. You have to be able to show you have some injury in order to appeal. But otherwise there is an appeal available for petitioners, and patent owners can always appeal if they lose. You also have very highly skilled administrative patent judges handling these cases. These are people with a technical background. For example, if you had a chemical case, you might have judges with Ph.D.s in chemistry or related discipline. They have legal training. They're all patent lawyers. And so you have a panel of 3 of these judges handling the IPR. And so I think challengers feel like that's you're going to get a fair decision. And the quality of the decisions from the Patent Office Board handling these cases is really high. And so, as opposed to, if you have a jury trial where you have laypersons trying to resolve patent issues, that can be much more uncertain. Another reason these are viewed as a good option for patent challengers is many of these cases are in litigation. And if you have a case that's in litigation, you can oftentimes persuade the district judge to essentially put the litigation on hold while the Patent Office decides whether the patent claims are valid or not. And so for a defendant in a litigation, this can be a really good option, rather than facing the prospect of a trial, perhaps a jury trial that's been docketed. If you're able to get one of these things instituted, then your district judge might delay trial, delay the district court case from going forward at that time. It's also procedurally difficult for the patent owner to change the claims, to amend the claims. The statute does allow the patent owner one opportunity to amend the claims, but it's really difficult to do that. And the Patent Office has not granted very many of those motions to amend. And so procedurally, the challenger sort of has the patent owner kind of hemmed in these proceedings, and it's in a really, patent owner's in a really difficult place if it's instituted. There are other procedural advantages as well. For example, at the institution stage, it's really difficult for the patent owner to put in any evidence because the Patent Office basically weighs that evidence at the early stage against the patent owner. So procedurally, it's very favorable for a challenger. It's also a lower cost type proceeding. There's very little discovery, unlike in a district court case. There's typically no live testimony at the PTAB final hearing. And so that's, they're not inexpensive procedures, but compared to district court, they're just a fraction of the cost. So from a challenger standpoint, it's a very appealing procedure in that regard as well. Settlement, in terms of settlement, these cases, these IPRs can help with settlement. If you're, for example, a startup and you've been threatened with a patent by some other company, and if you are able to put together a good IPR challenge, you might even just, sometimes we've seen those potential challenges raised during settlement negotiations, and that can help you get a settlement because the patent owner knows that there's a good risk, there's a significant risk to its patent if one of these IPR proceedings is instituted. And so oftentimes, even just the possibility of an IPR is something that's helpful for getting a settlement, maybe getting a license, maybe opening up some technology that you thought might have been closed off to you through patents. Also, there is an estoppel provision in the law, but it so far hasn't really precluded petitioners from going forward. So the estoppel means, for example, if you were to bring a case, an IPR challenge, and you were to lose all the way through appeal, you couldn't then raise the same exact arguments in a district court litigation because you basically chose the Patent Office as your venue for deciding those types of issues. But that hasn't really been a problem and hasn't dissuaded people from using this procedure, given the very high rate of cancellation of claims and the high success rate. So these are just some of the advantages of what's really driving this, as I said, really transformation of US patent practice, with a lot of patent validity issues essentially being litigated at the Patent Office as opposed to in a district court. And these are some of the reasons for that big shift in US patent practice.
No, I don't. So this is Mark again, and all of the reasons that Mike has mentioned on why IPRs have become so popular are really a double-edged sword, in that if you're the patent owner, the IPRs are a popular tool to use against you. And so we're just trying to advance. We tried to advance to the. Okay, so we're there on the next slide. So all the reasons why IPRs are popular become a threat to you as a patent owner. So it's a great tool when you're the petitioner. The shoe's on the other foot where you're the patent owner, and your bigger competitor, your smaller competitor can come out of the woodwork and knock out a patent of yours, or try to knock out a patent of yours that you've asserted or not asserted. And so as a patent owner, you generally dislike IPRs, and it takes new thinking as things have been transformed, as Mike said, on how to make your company IPR ready. And the very beginning of how to make your company IPR ready really starts with obtaining patents that are stronger just from the start. And so, you know, in that regard, there's not so much you can do with things you have filed already, but for the patents that inventions you're still developing and that you're going to file in the future, they need to be stronger now because, as Mike said, a very experienced panel of judges is going to be able to review it, and the challenger is going to be able to come in and kind of quickly attack you. So what does obtaining stronger patents mean? You know, there are older theories of how your patent is drafted that you just sort of put the bare minimum in that minimally meets the thresholds for describing it and disclosing it, and where, you know, you don't spend a lot of time looking at the prior art, much less distinguishing the prior art. But to obtain a strong patent, you need to do all the opposite. You need to go and you need to be fully aware of what the prior art is. Because if you draft a claim and you're not really aware of some critical piece of prior art that then your challenger comes and brings to the patent office, well, it can be game over. And similarly, you know, it's generally viewed that between the patent examiner and that reviews your patent application and the more experienced judges in the Board of Appeals that review an IPR, that the examiner is an easier audience, especially on these 112 grounds of written description and enablement and definiteness. And so just because you got a patent through the examiner, it doesn't really tell you that it's going to be a strong patent for the next level of review with the board. And so it means drafting your patents and prosecuting them from the very start with the idea that this could very well one day go to the patent examiner. So that's step one, at least for patents going forward. Make it a strong patent, not just to get allowed, not just to be a piece of paper, but something that's going to withstand challenge by a motivated opponent. So step two is you already have a portfolio. You know what patents may be covering your product. You may know what patents you have that may be blocking competitors from getting into your space. Well, go review those. Make sure that there's not some piece of prior art out there that you don't know about. Make sure that you feel good about how the claims are drafted. Make sure you feel comfortable about the support, because there are remedial things you can do with if you discover some piece of prior art that you didn't know about, or if you realize that you inadvertently claimed too much or too little, you can go and remedially fix up your claims in a more forgiving procedure than is available in IPR, but you usually want to do that first before someone starts a challenge. Mike mentioned that the patent owner has one option to amend their claims, and that in practice, it's a very narrow and very limited option. If you're the patent owner, you would like as much flexibility as possible in amending your claims, and the maximal way to do that is to keep a continuation application pending, essentially, if possible, for all time, or at least for all time that the patent family still has a commercial value. And just to make sure that being clear, what a continuation application means is that in US patent practice, you can file a patent application and you can file basically a child application off of there that is just, as it says, a continuation. And you can do this basically as much as you want. You can have as many continuations off of a starting point as you like, and it's possible for each one to mature into a patent. And so one initial filing can lead to a whole family of patents with, you know, slightly different claims, focusing on a method or focusing on the composition of matter or anything. But by keeping a continuation application pending, if something comes up in an IPR where there's a piece of prior art that you weren't aware of, you have free reign nearly in the continuing application to amend the claims as you like. And so you may be able to redraft better claims and moot any issue that has come up in the IPR. And so it's very powerful to keep a continuation application pending. There are other reasons too, not just for an IPR. You know, you may have disclosed in your original application a lot of detail, and your invention may have a lot of aspects to it. And over time, as you see how the market changes, you may see that there are things that you initially disclosed that you want to incorporate into the claims to better protect your company's interests in the marketplace. So the fourth bullet is about maintaining contacts with the inventors and technical experts. It's always important when a patent is being challenged to be able to go back and get information from the inventors to clarify what they were thinking, what the support was, how they understood their invention differentiated over the prior art. You may need declarations from the inventors. You'll certainly in an IPR proceeding need declarations from a technical expert. And that's the way testimony goes in primarily. It goes in primarily through declarations of technical experts. And if you have a patent and you wait until it's challenged before you have set up your network of technical experts, it can be too late to consult them in sort of a rushed manner. Sorry, we're just getting a little feedback. The next thing on the list is that you need to have a team that has litigation experience and patent office experience. The demands and considerations that you need to be considered affect both how the patent is defended in the patent office and how it's going to be used in litigation. And if your patent office team only has, for example, a patent prosecution background, you know, they just may not have the foundation to consider how statements they make on the record, arguments they make to keep the patent valid, may inhibit you being able to assert this against a litigant later. And so one of the not 101 level tactics, but a 201 or 301 level tactic is to go in and file an IPR against your competitor, not necessarily with the idea that you're going to invalidate the patent, but that you're going to force them to take a position, for example, on what the claim terms mean, that will then give you a non-infringement position. And so this is why it's important that a legal team knows how they're going to want to enforce the patent later. It can't be done, at least not done well, in isolation. And the last piece is you need to have management and business buy-in to why do you care about an IPR. Depending on the interest level in IP and the level of sophistication and just the level of experience, people sometimes see a patent, you have the issued patent, you have the beautiful red ribbon on it, and you're done. And there's nothing more to do. But it's not the case that once you have the patent issue that is done and protects your invention for all time going forward. As Mike said, the statistics show that your patent, especially if it's a good one, that blocks competitors, has a high likelihood, if attacked in an IPR, of being invalidated. And so there's a level of continued diligence that's required if once you have a patent to be able to be ready to defend it in an IPR.
Okay, so now let's talk a little bit about patent owner strategies in trying to avoid institution. So just stepping back a little bit, the way that these IPRs start is someone files a petition. So the petition essentially is let's say a 50-page document that explains in detail why the petitioner thinks the patent claims are not valid. And they cite the evidence that they're relying on. And as we said, for an IPR, that would be prior art patents, prior art publications. And the petition will also attach expert declarations. So for example, if you had a chemical case, you might have a declaration from an organic chemist. You might have a declaration from a chemical engineer. So that's the way the evidence comes in the petition is through written testimony from expert witnesses. So if you get hit with one of these IPR petitions and you're a patent owner, it's a really critical thing to just move very quickly to try to evaluate the issues. As I said, these are really fast-moving proceedings, and so the patent owner really has to get its act together quickly in terms of coming up with its counterpositions. But I think maybe the most important thing for you to take away in terms of strategy from the patent owner standpoint from our presentation today is that the most important stage of an IPR from the patent owner standpoint is the institution stage. And essentially, if you're a patent owner, you want to do everything humanly possible to avoid institution of an IPR. Well, why is that? Well, as we said, once a case has been instituted as an IPR proceeding going forward in this process, the Patent Office most of the time is going to cancel all of the claims. So on the other hand, if you avoid institution, if the Patent Office concludes at the very beginning of the procedure that there is not enough evidence here to go forward with an IPR, in other words, there isn't a likelihood that at least one claim is unpatentable, if they reach that conclusion at the early stage and they decline to institute, then that's a win for the patent owner. So it's really the best way to win a case if you're a patent owner, and the best way to protect your patents from these types of challenges is to come up with a really strong argument to avoid institution. Now, what the patent owner does in this situation is the patent owner, and you only have about 3 months to put this paper together, but the patent owner can put together and file what's called a patent owner preliminary response. And that's filed about 3 months after the petition is filed. In this response, you can raise arguments as to why you don't think the petition shows that at least one claim is unpatentable based on the evidence that's been submitted. So it's critically important to persuade the Patent Office not to institute. And we've listed here on this slide a few examples of arguments that we think you want to consider making in this situation. And maybe I'll start by saying what you don't want to do. And I think oftentimes we all have a technical background, and your companies are technology companies. So if you are sort of hit with one of these IPRs and you read the IPR petition and it's all these technical arguments, let's say about chemistry, and you disagree with their analysis of the chemical reactions, let's say, that are discussed, or a catalyst that's discussed, technical people tend to want to respond with technical arguments. But if you do that in this part of the IPR procedure, oftentimes the Patent Office will say, well, they do have expert testimony supporting their position, so there's really just sort of a technical dispute here, so we really need to have a trial to decide who's right. So you really don't want to come in and just, argue technical arguments against the other side's expert, particularly if you haven't even put in any of your own expert testimony, and then you're just basically making attorney arguments, and you're going up against some highly credentialed expert who filed a declaration, to support the petition. So you really want to take a different strategy. And one thing to consider is there is a statute that says basically, let's say you're sued for infringement, you have 1 year to file an IPR petition if you have a pending case in district court. And Maureen and I have had a case as an example where we were in a district court litigation representing the patent owner, and the defendant filed 2 IPR petitions, but one day after the year had expired, and we were able to get the Patent Office to deny both of those petitions because they were even just one day late. So that's, if you have that situation, obviously you would want to raise that because that would be a basis to avoid institution. Another good argument concerns claim construction. So if you're familiar with patents, you know they have these numbered paragraphs at the end of the patent that essentially, that's the sort of legal definition of the invention that is protected by the patent. And interpreting what those words mean is as a legal issue that a court would normally do, or the Patent Office judges would interpret the claims. So if you had an IPR petition that was based on essentially an incorrect understanding or interpretation of the patent claims, that would be a strong argument for avoiding institution. You basically say the whole thing is just flawed, you know, from the start. Another example would be where the petitioner sort of overlooks an element of the claims. Let's say you had a catalyst composition that was claimed that had 3 components, A, B, and C, and they addressed A and B very thoroughly in their evidence and in their petition, but they really just didn't even discuss C. Well, you would then come in and say, well, they didn't address C, and so again, sort of on the face of it, it's not legally sufficient. And the Patent Office would then potentially not institute for that reason. You know, another example would be where the Patent Office has discretion in some circumstances to avoid serial petitions. So we've seen a lot of cases where a petitioner files a petition, they lose, and they file another petition. And so in that circumstance, there's this statute 325D, which we've listed here, that can give the Patent Office Board some discretion to deny follow-on petitions. Another example would be if the petition doesn't prove that something is prior art. And a good example of that, and we've had a number of cases that we've been able to get denied based on failing to prove that something is actually a printed publication. In the pharmaceutical area, a good example of that is a label, like a label for the drug product, and maybe it hasn't yet been included in the physician's desk reference, but if someone's trying to show that it was publicly available, and that can be very difficult for drug products. So if there hasn't been enough evidence submitted to show that something was actually a printed publication, that can be a strong argument for avoiding institution. And sometimes the petitioner fails to address the relevant factors of obviousness, such as reasonable expectation of success or unexpected results. So again, you want to look for arguments that are hopefully a legal argument, something where you can basically say, based on the surface of this petition, even without reading their expert testimony, it's not legally sufficient. And in that circumstance, hopefully the Patent Office won't institute. But I think, again, the most important takeaway from a procedural standpoint, from the patent owner standpoint, is this early stage of the IPR is the most important part of the proceeding from a patent owner standpoint. And really, each case is different, but you have to come up with some strategy to avoid institution. And if you can do that, you'll be successful in avoiding the patent, your very important patent, being sort of dragged into this procedure that has a high likelihood of ending up with the claims all being canceled. So that's just something we wanted to highlight today, was really the importance from a patent owner standpoint of that earliest part of the procedure.
This is Mark again, and in terms of, let's go forward one slide. Okay, using IPRs to challenge, this is exactly the flip side of everything Mike's just said. Now you're the challenger, and you don't like someone's patent, and all the points Mike made about as patent owner, what do you want to respond to? Well, these are all things that you have to do carefully and get your petition perfect from the start. The petition that is challenged to attack a competitor's patent is very different than what you do in a district court litigation. If you're going to institute a district court litigation, even if you have a basis to invalidate another company's patent, it's really much more of a bare bones assertion to where you say, we would like the court to consider the invalidity of this patent on some general grounds, but you don't have to lay out your case, you don't have to lay out your detail, you don't have to provide your experts. Here, when you're filing this petition that then the patent owner is going to try to prevent, you pretty much have to front load all of your work and get all of your grounds and all of your arguments and all of your evidence into that opening petition, because that may be the only time you can put on affirmative evidence in your case. And so the drafting of this IPR petition, it may take 50% of the budget as a petitioner, because you're going to work. It's not a summary document. It's not an outline document. It is all of your argument evidence put there for the patent office to evaluate to the end of the case. And so that means that you've worked with your experts in detail and you have their detailed analysis in there, going very carefully through all the prior art you're relying on, and you want to be smart about it. You know, there are statutes, but there are also the judges are all people, and you need to be persuasive. And it becomes more persuasive if you find prior art that is closer than what was considered by the patent office. You know, the patent office always considers some prior art, and obviously it was overcome or there wouldn't be a patent in the first place. But if you can find something closer than what the patent office used, it becomes stronger. And so it's a persuasive piece, and I don't think we need to go through all the pieces, all the bullets here, but your petition has to be front-loaded with all of your arguments and all of your evidence, and you have to be persuasive without overstating your case. If you overstate your case, and you can lose credibility, and when you lose credibility, they can ultimately decide everything against you. So I think that's the main points. Again, the flip side of what Mike said, without going into all the details, and maybe save a little bit of time for a question or two. We can maybe leave up a slide just so that people know, you know, there are fees for the patent office, about $15,000 for the fee, and then $15,000 if it gets instituted, so that the patent office fees are around $30,000, which is more than what it costs to institute a district court litigation, but in terms of the amount of time then that you need to put into it, the IPRs are much more cost effective. So Maureen, do you want to turn to a question?
Sure. So we have a few questions that will round out the rest of the period in. So one of the first questions is, how difficult is it to expand the scope of your patent after it is filed? And I think there's a couple of layers, and I'll talk a little bit about that and then hand it off to Mike and Mark to further discuss. So the term after it's filed can mean after you initially file your application with the patent office. And so if you're trying to broaden your claims at that part to, say, capture something else that's in the body of your document, in the body of your specification, at that point you just can file some claim amendments or a continuation application that Mark mentioned earlier to capture some of that unclaimed but described subject matter. If you haven't described it at all in your original patent, then you're going to be up against some difficulty, and you may have to consider filing a new patent application. So that's why patent drafting, that process should be very deliberate, really an iterative process between your attorney, the inventors, the company, to really make sure that that first patent application fully captures every aspect and potential aspect of your invention, and describes your subject matter in broad and in narrow detail. After it is filed, there is something called a or excuse me, after your patent is allowed and you have a set of claims there, those claims define your invention. There is something called a broadening reissue application, which can occur 2 years after you get that patent if you realize that you left some cards on the table. You left some things out of your claims, but those are fully encompassed by the description of your spec, and you want to make sure to capture those. You can file something that's called a broadening reissue application. Also, as Mark already emphasized, it's really important, especially with IPRs these days, to maintain those continuation applications so that if you realize after the fact, after your patent issues, and you don't have a continuation, you have to go kind of through these other routes, which can be a lot harder than if you could just file those broader claims in your continuation application. And then if you're in an IPR and you want to get an expanded scope of your patent in a motion to amend, that is actually prohibited by the motion to amend process in an IPR. So one of the few things that the Patent Office looks at right off the bat when they look at an amendment that's filed as part of an IPR or a PGR is whether or not the scope of the claims is expanded. And so if it is expanded, the motion to amend is summarily denied. And so Mike and I had a case where we were able to have patent owners' motion to amend denied because they had expanded the scope of their patent claims. So Mark and Mike, I'll turn it to you to add anything to that.
Maybe move to the next question. I think you covered it.
Sure. So in the beginning, you both discussed that the purpose of the AIA was to avoid kind of what was happening before with kind of extortion and the costs of big trials. In your experience, especially in these chem and bio areas, have IPRs been able to facilitate litigation settlements or license negotiations?
They certainly do, and I think I alluded to this a little bit earlier. Even sometimes just the possibility of an IPR being filed against a patent will motivate a patent owner to license its technology, license its patent. So it's a really important takeaway here. If you're involved in discussions with patent owners as a smaller company, the possibility that you might challenge one of their patents through an IPR could be pretty significant leverage. Sometimes we see that maybe it doesn't work at that stage, but then you go ahead and file it, and then that even after it's filed, an IPR can be settled, and a lot of these do settle, and that's also important to understand. Settlement is better earlier than later. If you file an IPR and then the case goes forward and it's fully briefed, and if the parties settle at that point, the Patent Office will allow the parties to settle, but they still might decide the patentability issue because there's a public interest consideration. So just keep in mind these IPRs can be settled. Sometimes things settle before they're filed, sometimes they settle after they're filed. And that's an important part of license discussions oftentimes with patent owners.
Okay, and it looks like we are right up to the time, so I'd like to thank Mark and Mike for the very informative presentation and pass it back to Julie.
All right, well, thank you all very, very much. I really appreciate your time today and the opportunity that you provided to share your expertise. So thank you, Mark, Mike, and Maureen, very, very much. As we wrap up, just for planning purposes, everyone has the opportunity to consider participating on part 3 of the webinar series coming up. Registration is available online. And finally, as a final reminder, the GC3 Innovators Roundtable is May 8th through 10th. And registration is open with the early registration deadline approaching this Friday. So feel free to get on the website, get to those links, and register to save you guys a little bit of money in registration. And with that, I'd like to thank everyone for joining us. And again, one final thank you to Maureen, Mike, and Mark for presenting today. Thank you again.
Thanks for having us.
Okay. Thank you guys for putting this together. I think it was really smart to have very few slides.